Some of the banks facing prosecution from the Competition Tribunal for manipulating the exchange rate have denied any wrongdoing, claiming their own investigations have exonerated them. They've vowed to conduct further investigations to prove their innocence. The Competition Commission announced that it will be charging 28 local and international banks for manipulating the rand against the US dollar. In a statement, the Rand Merchant Bank says it investigated the matter when it surfaced in 2015 and had found no wrongdoing or unethical behavior. The bank intends to investigate the additional information referred to in the affidavit and says it's confident that it has not been party to any conspiracy to manipulate the local currency. Nedbank says it's committed to free and fair markets within a healthy and competitive landscape. It's in the process of reviewing the allegations and will respond in due course. ABSA Bank says when the Commission referred the matter to the Competition Tribunal, it did not seek any penalties against the bank. The case relates to collusion to fix prices and divide markets in respect of the US dollar and the rand in contravention of the Competition Act. Well, for more on this story, I'm joined via Skype by the Competition Commissioner, Tembinkosi Bonakele. Thank you so much for joining us, Commissioner. So, obviously, you know, you've come up with these allegations. You had referred the matter to the Competition Tribunal before, and for some reason you had to take it back. What fresh evidence do you have against these 28 banks?
Well, Nombo, if we could just step back, the reason why we were asked to file a fresh papers on the matter is that the foreign banks especially had contested the jurisdiction of the South African authorities because the conduct happened outside the country. So we've had to go back and now show that even though the conduct happened outside the country, it had an immediate and direct impact on South Africa as ordered by the Competition Appeal Court. So we have now filed this after doing all of that work.
So jurisdiction doesn't really matter in this particular instance?
Yes, this is what the court has confirmed, that they can find, jurisdiction can be found by virtue of the effect of the conduct in South Africa. So in other words, we have to show that there is some information, some evidence that the conduct did have impact on South Africans.
So, Commissioner, what's your reaction to some of the banks coming out and saying that they have done their own investigations and as far as they're concerned, they've done no wrongdoing and there's been no unethical behavior?
They are also saying they are doing further investigation, and I encourage them to do so because I think that now provided more particulars in this particular referral. And I hope that it would be helpful to them so that they could answer. What we need is to put this thing behind us as soon as possible,
yes,
through a hearing or settlements.
So, Commissioner, if the Competition Tribunal agrees with your findings, what sort of penalties are you recommending to be imposed on these banks?
We've asked for 10% of turnover, but typically how that is calculated is to look at the affected turnover. So they would look firstly at the revenue that's attributable to the trade in rand and the dollar, and then there would be all sorts of calculations done on that to arrive at a penalty.
If the charges you've raised against the banks are found to be correct, shouldn't the individuals involved and even company directors be charged with some sort of criminal offence like fraud? Or would the matter of burden of proof be an issue in the criminal context because you have to prove beyond reasonable doubt?
Well, I suppose we will cross that bridge when we come to it. The allegations are indeed quite serious, and it remains to be seen whether there are any further steps to be taken. I frankly would like to take it one step at a time. But also, we have noted that some of the traders who were involved have been dismissed by the banks themselves. But what is curious is that the banks have still not accepted responsibility for what those traders did.
What happens in the case where perhaps you've got rogue traders? I mean, if you remember what happened with the Barings Bank, obviously the person who blew away people's investments didn't have the sanction of the company. What happens in those instances? Can't they put their hand up and say, well, we didn't sanction the behavior?
It would be helpful if they did that. But of course, the law does have a presumption that if you are employed and you do something in the course of your employment, your employer is vicariously liable for your actions. But I think that debate would be a start. If they could come forward and say, our traders did this, we distance ourselves from it, that's at least the beginning of a discussion.
Yes. And one last thing, Commissioner, when it comes to the fines that you levy against whatever company or industry or sector, I can hear your child in the background, where do the funds or the proceeds actually go?
The proceeds go to the National Revenue Fund for all the penalties.
Right. And isn't there an argument that perhaps to try and bolster your job and your capacity, that some of those funds should actually go to you so that you can do a better job, so to speak?
I think you can advocate for this with National Treasury. We are trying various means of persuading National Treasury, including looking at the income that they themselves receive from the penalties to bolster the resources of the competition authorities. I think those ideas actually are fair for in these fiscally constrained times where you are seeing budget cuts. Yes. How do you sustain a competition authority? I think looking at a portion of the penalties is one option.
All right, super. Thank you very much, Commissioner, for joining us. That was Tembinkosi Bonakele. He's the Competition Commissioner.